Next question is from Melissa Code.
Hi, Mr. Mundine, Melissa Code from the Mandarin. I'd like to ask you some questions about the no supporters' position on the referendum proposal being legally risky. So earlier this week, we had the Law Council of Australia, some leading constitutional law experts, Kenneth Hayne, Cheryl Saunders, reiterate that the proposal was safe and modest. But today in your speech, you talked about concerns about the permanence that the voice represented, and you also talked about worries about how this was opening a racist conversation. There are existing race powers in the Constitution. How do you reconcile that fact against the position you take? And also, what is your view on a kind of dispassionate, apolitical expert position that it's a safe and modest proposal?
Well, I don't believe that. And you know why I don't believe it? Because the Law Society of New South Wales, Victoria, Western Australia and so on are in the yes camp. Why would I trust them? This is the insanity of the Law Society in them to actually take a position on this. Because if I get in trouble with the law, how do I know I'm going to get a fair trial from those lawyers? How am I going to know if I'm going to be treated decently? Because they signed up to the Yes campaign.
Sorry, Mr. Mundine, what has that got to do with the Constitution, amending the...
It's got a lot to do with it because it's about our legal system. Our legal system, if people remember outside our courts and everything, it is a statue of a woman who's blindfolded, who dispassionately looks at is only dealing with the evidence. It's got nothing to do with race. It's got nothing to do with religion or anything like that. It's about whether a person has committed a crime or hasn't committed a crime.
Mm-hmm. And
that's
so,
what the law is about.
So
how can the law societies, quite frankly, who are the guardians of our legal system, can sign up to one side of politics?
I believe
it's just insanity for them to do it.
I believe the position is, and just to give you an opportunity to respond, because the Constitution represents a framework of principles.
Yes.
And this is a way to give Indigenous recognition, and so that recognition isn't symbolic, the voice exists. So would you like to respond to how that is problematic and legally risky?
Well, it is because, lawyers are like economists. You get two lawyers in a room and you get 3, 4 or 5 different debates. I've got, and it's amazing, I've got lawyers and constitutional lawyers, professors of laws and that, who dispute that. So this idea, and this is where I know where the Law Society is getting itself in big trouble, this idea that the Law Society can say this is the answer is fallacy. It's just nonsense. And it opens it up for a legal argument.
Melissa, we will have to move on, but I think in fairness, one of the people who's supporting the voice is a former Chief Justice of the High Court. He's not a practicing lawyer. We're talking about Robert French. So, yes. Or Ken Hayne, another former High Court judge. Are they wrong? Are they wrong? I mean,
I'll tell you what.
You
know who's the Chief Justice of the Supreme Court who just retired? Kiefer, right? She was outvoted by the other members of the High Court on the Love case. So just because you're a Chief Justice or just because you're a Justice doesn't mean you don't get outvoted by your fellow Justices. They do.
Right. He does happen to be a former Chief Justice.
I know he's a former Chief Justice, so is Kiefer, but she got outvoted. Okay, you've got to be consistent. You've got to be consistent and face the facts. And you're not doing that, David. I'm sorry.
No, I'm giving you a chance to respond. You have the podium. It's only...
Yes, all right, that's fine. The fact is that the Chief Justice is not the complete fountain of all legal arguments. And I just pointed out to you that Chief Justices have been overruled in the High Court. And that's a fact.
The next question is...